Hi, this is Advocate Afreen Hossain, currently practicing at Unreported Judges Court, Kolkata. And in today's video, we are going to talk about the most talked about topic in India, which is domestic violence against women. According to the latest National Family Health Survey, NFHS finds around 1 out of every 3 Indian women have suffered some kind of spousal abuse, and around 6% have suffered sexual violence. The NFHS 5 survey 2019 to 2021 was conducted in around 6.37 lakh Indian households in 707 districts of 28 states and 8 union territories, covering around 7,25,000 women and 1,02,000 men, to provide disaggregated estimates up to district level. In India, more than 55% of the women undergo domestic violence attacks, especially in the states of UP, NP and other northern states. According to the United Nations Population Fund report, around 2/3 of the married Indian women have been victims of domestic violence attacks, but most of the women, they prefer staying with their husbands for the sake of their children, and while others, they resist themselves from filing any case because either due to financial instability or for the fear of undergoing any kind of public shame or scrutiny. Hence, most of the cases of domestic violence remain unregistered in India. However, it is very important to raise your voice against the gruesome act by the husband or his relatives rather than enduring it. The offence of domestic violence is covered by both Section 498A of the Indian Penal Code 1860 and by Domestic Violence Act 2005. However, both these acts only treat women as the victim and not the man in the relationship. Hence, only the women can seek relief through it, which is a very big drawback and a very big loophole about which I shall be talking in one of my next videos. So before delving into how to find a domestic violence case in India, let's understand what domestic violence is and what all domestic violence covers. Domestic violence, as defined in the Section 3 of the Domestic Violence Act 2005, includes any kind of harm or injury to the life, health, limb or well-being of a woman, whether physical or mental, or any kind of harassment with a view to force the woman or any person related to her to meet or to fulfill any unlawful demand of dowry. Now the question arises, against who can you file the complaint? So, if you are being constantly tortured and ill-treated and you are in a constant trauma due to acts of your in-laws or in your matrimonial home, then you can immediately file a legal complaint against any of them. It is a general misconception that the act of domestic violence can only be committed by the husband against his wife, which is totally untrue. Any woman can file a legal complaint against the husband or any of his relatives. Also, if a woman is in a living relationship with a man and if he commits such crime of domestic violence, then she can file a complaint against that man in the living relationship as well. Now coming to the procedure for filing a domestic violence complaint, the victim or any other person who is a witness of the offence on her behalf can file the domestic violence complaint to the local police officer or the protection officer or the service provider or directly to the magistrate. Now the first basic question which comes to the mind while filing the case is that which court should be approached. So the domestic violence case will be heard by the judge within whose local limit the accused resides or the victim resides or where the offence has been committed. Step 1. The magistrate shall, upon receiving the complaint, commence the hearing of the case within 3 days of the complaint being filed. Step 2. The magistrate shall give a notice of the date of hearing to the protection officer who shall issue it to the accused. Step 3. The court shall, as far as possible, dispose the case within 60 days from the date of the first hearing. You can even request the magistrate to conduct the hearing on camera. That is, you won't be required to be present for the hearing personally, and the entire hearing will be conducted via video conference. Step 4. The court, after conducting on the hearings of the case, if satisfied that a genuine domestic violence case was filed and that the accused actually committed the domestic violence attack, then the court might give the following or any of the following orders, and also the victim can also request the court to give any of the following orders. A. Protection orders. The court can further restrain the accused from committing any kind of domestic violence attacks on the victim or the family members of the victim, and the court may also disallow the accused from entering the victim's residence or place of employment. The protection orders can be claimed by the victim as an interim relief before the final judgment is passed. B. Residence orders. Now, if the court is satisfied that the victim has no other place to stay or for any other reason maybe, the court can prevent the accused from dispossessing the victim from her matrimonial home, and even can disallow the accused to enter into that part of the household where the victim is residing. C. Monetary relief. You can even ask the court for monetary relief from the accused to incur your medical expenses and any other loss that has occurred to you as a result of the domestic violence attacks. D. Custody of the child. The court can also grant temporary custody of child or children to the victim depending on the circumstance. E. Compensation orders. In addition to all these reliefs, the victim can also file an application to the court for compensation or damages for the injuries caused by the accused, including mental torture and emotional distress due to the acts of domestic violence. These orders will remain in force until the victim files an application to the court for its revocation. If the order of the court is not passed in the favor of the victim, then the victim can also file an appeal against the order passed by the court within 30 days on which the order was passed by the court. The victim can also file a case under Section 498A of the Indian Penal Code 1860, which also deals with domestic violence offences and provides for punishment, which is 3 years of imprisonment or fine or both. The victim can file the FIR under Section 498A of IPC against the husband or his relatives to the local police station of the victim's area. So hopefully today's video was useful and helpful, and I will see you in court. Just kidding. See you in my next video. This is Advocate Afreen Hossain signing off.